Good morning, everybody. So we're going to start just on time. I'm really glad you're all here. The first part of the day is going to be in English, and then the second part, the roundtable, will be in Hebrew. And I'm very happy to see all of you here to discuss the very important topic of a national referral mechanism for victims of trafficking generally and in Israel. So we're going to start from hearing about the UK experience, and I'll introduce our speaker in a second. I'll just say that, I'll just say that yesterday we had dinner with Leticia and heard about the UK experience and found out that sometimes having an informal system in place has its benefits. So that's something it'll be interesting to think about today when we hear what she's talking about. But I'm thrilled to have this conversation here today, and I'm sure it's going to be extremely fruitful. So let me introduce our speaker, which I'm failing to pronounce her name correctly each time. So Leticia Ishibashi from Flex, an amazing organization in the UK focused on labor exploitation. It's a research and policy organization. And Leticia coordinates the work of the Labor Exploitation Advisory Group, which is basically a group of service providing NGOs and not just NGOs, governmental, just NGOs, of NGOs who provide services for victims of trafficking. So they have a forum that Flex organizes. And prior to joining Flex, she worked supporting the engagement of grassroots and community organizations in human rights mechanism in Thailand, and she holds a master's in social policy and development from the London School of Economics. We're extremely grateful to have you here with us, and we look forward to hearing you. Then we'll have Maayan Niezna, who's a visiting researcher at TraffLab, but also a doctoral student at Kent Law School, writing an extremely interesting dissertation on the issue of trafficking and forced labor that I'm sure we'll all hear more about in the future. But now, so thank you all for coming, and Leticia, the floor is yours, and I'm going to hand this to you. This is actually not a mic. This is just for the video. Okay. So when you start, let's see if people can hear you. Otherwise, you can use this.
Okay. Thank you for having me. Thank you, everyone, for coming. So as Hila said, I work for Focus on Labor Exploitation, and I coordinate this group called the Labor Exploitation Advisory Group. And by coordinating this group, we actually find out what happens on the ground. And one of the good things about the group is that it's not just organizations that work specifically on trafficking, but they work on a variety of issues, such as working with immigration detainees or working with victims of domestic violence and domestic abuse. And then through that, we find how various different types of abuse are actually connected to each other, or one person can suffer multiple types of violations, and then therefore we're better able to identify people that don't self-identify as victims of trafficking, and people also that might have suffered labor abuses, a series of labor abuses throughout their life, and might have never been identified through regular mechanisms. So I've left one of our publications that explains a bit about that, but I'll talk about this in more detail. Okay, cool. So a bit about the legal framework in the UK. So we have these three legal frameworks that pretty much govern the way that the UK deals with what we call modern slavery. In 2017, the Council of Europe Convention on Action Against Trafficking in Human Beings was established, and then that led to the creation of the UK National Referral Mechanism in 2009. Then the EU directive from 2011 defined that there needs to be a minimum of 30 days service provision for victims of trafficking while they are in the national referral mechanism of each European country. And the UK has decided to go a bit further than that and guarantee 45 days minimum. Within these 45 days, people have access to safe and secure accommodation. They have access to therapy and other mental health and physical health services. And they're supposed to recover from the situation that they were in and be able to be to move on from that and either go back into the community or seek return to their country of origin, or however that works out for them. And then very interestingly, in March this year, it was found that the 45 days that the UK guarantees is actually not enough, and it's causing more harm than it's causing good, because a lot of victims, they entered the system already panicking about not having, like, becoming destitute or becoming homeless after these 45 days. So that was creating a great amount of stress that was being added to the trauma. And the High Court has found that to be illegal, therefore, unlawful. And therefore, at the moment, people are receiving support on a needs basis. So after the 45 days, they keep receiving support, and then ideally what we would like to see is an independent doctor or healthcare professional saying that that person should receive the amount of care, and that should be ongoing evaluated. But at the moment, the needs basis aspect hasn't been defined yet, so we don't know what that actually means in practice. But it's good because people are now not being just dropped after 45 days. Then in 2015, we had the UK Modern Slavery Act, which some of you might be familiar with. So the Act looks at modern slavery in general and looks from everything from supply chains to victim identification and support. And within the identification and support, this means that victims of modern slavery in the UK now have their protection expanded to both England and Wales that are covered within this act, and then Scotland and Northern Ireland will have their own separate piece of legislation. Scotland, for example, has even better identification and support mechanisms than England and Wales, but that it was supposed to kind of streamline the knowledge about this issue in the country. Within modern slavery, the UK understands that to cover slavery, servitude, forced or compulsory labor, and human trafficking. And that's like an umbrella term for all of these issues. But there's one limitation in terms of human trafficking in the definition in the Act, because instead of using the international definition that was established by the UN, the UK's definition of human trafficking specifically is really focused on the transport of people for the purposes of exploitation. So whilst in international law you would have harboring, for example, as already constituting human trafficking, in the UK you need to have transported that person from one place to another with the purpose of exploitation. So it's a bit narrower. We spoke to a lot of government representatives about that, and they feel like the other definitions still cover what would not have been covered by that. But it's a shame that it doesn't follow international regulations on it. Yeah. Then these are the figures for last year in the UK. So almost 7,000 people were referred into our national referral mechanism. And as you can see, the number of victims of labor exploitation is significantly higher than those of sexual exploitation. And that has been this way since the NRM was started recording and publishing data. So since 2012, there was always more victims of labor exploitation than there were of sexual exploitation. And by labor exploitation here, I mean both what the UK categorizes as labor exploitation and domestic servitude, because we see that as labor exploitation as well. They collect this data, so every quarter they publish this data, and then every March they compile the data for the whole year before and then provide this information to everyone. But there are limitations both in the way the data is collected and the way that the data is published and what we can use this data for. So, for example, when we talk about labor exploitation, we don't break down into which sectors people were found, with the exception of domestic servitude. So we don't know whether people are being identified in construction and if they're being identified in cleaning, for example. And there's also a conflation of numbers of formal economy sectors, such as construction, catering, and cleaning, and also illegal trade. So, for example, cannabis cultivation, which is a major sector that is being identified in the UK. While it's forced labor and trafficking, it's also a criminal act in the UK. Therefore, the types of solutions for these two issues are very different. So when you put all of that together, it becomes quite hard to see what's working and what is not in terms of identifying and which sectors which strategies in each sector are actually working and which ones are not, and therefore we should be doing better work to identify people. So the UK national referral mechanism is a bit different from what I understand the Israeli system works, in that we have two phases in it. Apologies. I'll talk about that in a bit. First, I'll talk about consent. So if you are a victim of modern slavery and you're encountered either by the police or by an NGO, you're supposed to be given all the information about what your rights are, how entering any type of support will implicate in your legal situation, but also in your immigration situation in the country. And ideally, what we would like to have is victims actually having informed consent over the decision to enter the NRM. But what we find is that that's not necessarily the case, so it depends on who is doing the referral. So, for example, we've seen cases where the Home Office, which is a body that is responsible for both immigration enforcement and for the national referral mechanism, when they find people, sometimes they'll just refer them without explaining to them what the NRM means, without explaining to them what trafficking means, and then people will find out later on that they've had a referral form completed. They've signed this paper that they weren't told exactly what it means because it's in English. They might not have been properly explained what the paper says, and therefore it wasn't informed consent, even though it says in the regulations that everyone that is being referred should consent to it, except if they're minors. So minors don't need to consent, but adults do. And if someone doesn't consent to entering the NRM, which does happen, and we'll talk about it in a bit later, statutory bodies have a duty to notify, which essentially means that they have to record that they've encountered someone that they assume is a victim of trafficking and that that person didn't want to enter the NRM, but that's just for a statistical basis. They don't have to record someone's name or immigration status or anything like that. It's just in terms of number. And we find that quite useful, actually, to see how many people are actually choosing not to enter the system. Although we do know there are way more people that are choosing not to enter because of their immigration status. I'll come to that in a bit. So if people do consent, they're referred to the NRM by a first responder. The first responder is usually an organization rather than a specific person, and it includes both statutory and non-statutory bodies. So within the government, there are all police forces in the UK are first responders, and that means anyone in the police force. So it could either be someone specialized and that knows a lot about trafficking, or just someone that works in a police station in a neighborhood. The Home Office, that again I've mentioned, is the body responsible for immigration enforcement, but also for the NRM. Local authorities, the labor inspectorates, and more specifically the Gangmaster and Labor Abuse Authority. So the labor inspectorate system in the UK is decentralized, so we don't have a Ministry of Labour or of Work. We have different bodies that are responsible for different parts of labour law. So the Gang Master and Labor Abuse Authority are responsible for identifying people in the continuum of exploitation. So from minor abuses like, well, I say minor, but like non-payment of minimum wage and non-payment of holiday pay, for example, all the way to severe exploitation like human trafficking and modern slavery. So they are the ones responsible for that. And within the labor inspectorates, they are the most active in identifying and referring people, even though the other ones also can do that. And then there are the specialized organizations that are the non-statutory bodies. So we have NGOs that work supporting children or supporting women, victims of trafficking specifically, but also then refugees and asylum seekers. And what happens is that often these organizations have a lot more knowledge about trafficking because these are specialized organizations, whereas if you go to a police force in the countryside of England, the knowledge about what trafficking looks like is going to be very different from a specialized unit that is based in Manchester or is based in London. So we find it quite difficult because when we've spoken specifically to the police about that, and what they've told us is that training doesn't work because if you look at the numbers of how many people are identified, for example, for domestic violence, that is a significant high number. So when officers get training on that, they are better able to practice what they were trained on because they see that with more frequency. But they don't come across victims of trafficking that often. Therefore, they get training maybe once they join the force or a refresher every now and again, but then because they don't see that on a daily basis, it becomes quite hard for them to even remember all the things that they were trained on, and therefore they don't consider training to be the most efficient. Also because turnover in the public sector is quite high as well, then you have to keep constantly training people and it's hard to build capacity. So what's been done in different places in the UK, but most specifically in London and in Manchester, is that they've been training specialized units within the police to kind of support other police forces in identifying. So in London, for example, the Met Police has a modern slavery and kidnapping unit that now just changed names. But essentially they are the experts on this issue, and if anyone in the police force has a question, they can go to them. But that's also an issue with then the police officer knowing that exists and then going to them. But there are efforts to make sure that there is internal knowledge and know-how on this issue. So then to refer people, I've put there in the middle, as you see, there are two sheets of paper. One of them is the oldest version of the referral form, and the second one with the Home Office logo on the top, that's the new version. So that started working in April 2019. So the pre-2019 is the other one. So the referral form works in this way. So someone will come into contact with a victim, hopefully will get their informed consent, or they should at least, and then they'll sit down with the person to disclose what has happened to them. And the first responder will then go through this form and then write down vital information about what has happened to the victim, personal information about like their nationality, name, and so on and so forth. The old form used to have 10 sections, and the sections went in quite a significant amount of detail on what different types of exploitation look like. So once you have a chance to look at it, it will show, for example, labor exploitation, and then under labor exploitation it will have a bunch of tick boxes where it says has not been paid their wages, passports were withheld from them, and was forced to work overtime, and all of that. And then the first responder is supposed to tick those boxes based on their discussion with the person. And then after that, there is a narrative section where they're supposed to write, to justify why they've ticked the boxes before, and then to write in greater detail exactly when and how things happened, and any additional details, for example, who the exploiter was, how their journey into the UK ended up being, if they were moved from abroad into the UK. The idea with that is to provide enough evidence so it's quite clear why certain criteria were checked, and then get the background onto that. So, for example, it's really important for first responders to really understand specifically how labor exploitation works, because when we do research with victims of trafficking, for example, we'll ask them, have you worked overtime? And they will say no. But then if you frame the question in a different way, you'll actually uncover that they have. So, for example, with people that work in cleaning in the UK, it's very common that their contracts say that they'll be paid the London living wage, which is £8.20 an hour, to work 8 hours. But what actually happens is that because of the way that the system is, the cleaning system is structured, they're asked to clean 21 rooms, for example, in a hotel in a day. And that's impossible to be done in 8 hours. So they end up working 3-4 additional hours and are not paid for that. So it's really important that the person being in charge of identifying victims actually understands the structure of the labor market in the specific sectors, and ideally in all the sectors that have high risk to exploitation, to really be able to ask the right questions and uncover that. Also, because what we hear a lot is that people will say, well, I came to this country to work hard, so I'm working hard. So they don't see that as being exploitation. It's the first responders' responsibility to ask those questions. Therefore, they shouldn't expect that the victim just discloses everything that has happened to them. And they have to be quite tactical in identifying something and following up on questions to be able to really understand what has happened. It's also their responsibility to make sure to cover in the NRM form whether that person has sought advice and support before for these issues or for previous cases of exploitation, whether they've been referred to the NRM before, because they might have, might not know, but they also might know and have either disengaged with the process or been re-trafficked, which happens as well. So it's useful to know that and know what has happened then because of that. And they should also check whether the person is in any immediate danger and whether they need support, such as like food, accommodation, and also health and psychological support that is immediate. I think, yeah, so in terms of issues that we found with first responders, because anyone within these organizations can do referrals, we've had cases of first responders refusing to refer people because they just simply didn't understand what the referral form was, or even giving the referral form to an NGO that was there with the person and saying, could you please fill this in, and then I'll just sign it. And also then having first responders fill in the form, but then fill in it wrong, so not filling in the narrative section at all, or just writing something like smuggled into the UK, which is not the case because the person has been trafficked, or writing names wrong, nationality wrong, and then that creates like a snowballing effect where then the victim ends up not having their case accepted because things weren't filled in properly. And the last thing in this bit is that the NRM is now going digital. So everything before April 2019 was done in these paper forms, and they were then submitted to the competent authority, who's the authority that makes the decision on people's cases. But from April, they're now trialing this electronic version of the system where I've printed the the online form, so you'll see that there's a lot less information, and we're not quite sure how we feel about that yet. There's not been enough time for us to properly evaluate how that's working. It's good to have it online because it's centralized, and then the data accuracy might become a lot better. But it's also an issue that before you could sit down with a victim on a time span of like 3 days, and then properly give them time to think through what they were saying, and if they wanted to stop, they could stop and rest or go home, and then come back and sit down and continue talking through it. Whereas now you have to do it all in one sitting. So it can be quite a traumatic and stressful situation for the victim, and there's no save button as well in the system, which means that once you go forward, you can't go back. So if you want to edit something that you've written before that you might have misunderstood, the system is not done in a way that is appropriate for these kind of issues. So now about the two-step system. So as I said, the UK decision-making process is done in two phases. So the first phase is called the reasonable grounds decision. This is the phase where someone has consented to entering the NRM, they have sent their referral form to the competent authority, and then the competent authority that makes the decisions on people's cases has up to 5 days to make a decision on whether or not there are reasonable grounds to believe that person could be a potential victim of modern slavery. And at this stage, there's no need to have any proof. So it's more based on what was said in the NRM form, do we believe that this is a potential case? If the decision is positive, then the victim is entitled to safe accommodation, legal advice, independent emotional and practical help. So, for example, they get subsistence pay, which is £65 a week anywhere in the UK, which is not a lot of money, especially if you live in a big city, and just protection in general. They have no right to work unless they're under a visa that right is retained when they enter the NRM. So European nationals can still work while they're in the NRM because they have the same rights as UK citizens. UK citizens can also work while they're in the NRM. And overseas domestic workers that have come to the UK in an overseas domestic worker visa that gives them 6 months to work in the UK with a specific employer, but if they leave their employer before their visa expires and enter the NRM before the visa expires, they retain this right to work until their case is sorted, which we see that as a really good thing and is actually discriminatory.
Right to work as a domestic worker or right?
Usually as a domestic worker, yes. Mm-hmm. Yeah. And there are NGOs that will support them with finding safer employment, and they are then, because they've entered the NRM, they're more likely to have specialized support. And what we see in the case of overseas domestic workers is that because only a portion of the people that enter the NRM can actually retain the right to work, those that have left their exploiter after their visa has expired don't have this right. So it's quite different how they can cope with the trauma and how quick their recovery is based on that. During the reasonable grounds decision, even though you're not supposed to have any proof at that stage, what we found is that the competent authorities are using all the information they have on victims to decide on reasonable grounds decisions, which we find a bit excessive. So, for example, if someone has made an asylum claim before and that asylum claim was refused, all the information in that asylum claim might be used to say, well, these two things don't match, therefore this person is either not telling the truth or why are they changing the account of the story. That is highly problematic because people that have experienced trafficking are very likely to have experienced severe trauma and therefore the way that they talk about their exploitation might vary from time to time. They might uncover new things about their experience that they might not have mentioned in previous either immigration applications or even NRM applications. And what we find is that victims that have a long immigration paper trail, so victims that have applied for asylum before or for different leaves to remain before, and also that have been in immigration detention before they've been identified, are more highly likely to not receive reasonable grounds decisions. So that's a kind of a big failure within the way the system is structured, because even though you're not supposed to have proof at this stage, this is not really being taken seriously. In terms of receiving a negative decision, it's possible to ask for reconsideration, especially if there is reason to believe that the decision maker did not have all the information that they needed to be able to make an informed decision. The issue with this is that in most cases, when someone is referred into the NRM, they don't receive a copy of their referral form, so they have no idea what has been written in that form. And we've seen multiple cases of interpreters interpreting things wrong, or then kind of, instead of saying exactly what the victim is saying, they do their own interpretation of what the victim is saying, and then therefore that information is not 100% accurate, and it might then clash with something else they've said previously and then lead to a negative decision. They may also want to then ask for their negative decision to be reconsidered if they have had new information resurfaced that was not included in the first NRM form. But then again, it's this issue of maybe you're raising something now that will clash with what you said before. Yeah.
Do the people making this decision have any guidelines?
There are, yeah. So there's a lot of policies and a lot of guidelines, and they're actually not too bad. The policies are quite thorough, and they talk about trauma impacting people's recollection of their exploitation, talking about how immigration status is also, so if someone has an insecure immigration status, there is very likely to also impact whether or not they want to engage with the system. It does cover a lot, but the issue is whether or not that is applied. So what we see specifically with victims that have insecure immigration status, they're very likely to get a negative, either reasonable or conclusive grounds decisions, because there's a lot more at stake in those cases, in kind of in recognizing them as victims.
And has there been any further litigation once negative decisions are brought up?
Yeah, so you can appeal. So there's two ways of appealing. So the first one is in reasonable ground decisions, where you actually just provide additional information, and then that's going to go again through competent authorities, and they're going to decide whether or not. And then the next one is through the conclusive grounds decisions. So that's the second and last step of the NRM. Yes, of course.
Approximately how many applications are filed annually? Like, because we can see the numbers of how many are.
Yeah, so the last year it was 6,000, almost 7,000, and then from those we have a lot of them that are pending. So if you see in December 2018, 3,867 decisions were still pending, either reasonable.
Up to 5 days. Right.
Yeah. So yeah, that's another thing. So it's up to 5 days, but we've seen it take 4 months, for example.
Is there a special unit or division that's specifically doing this? Is it NRM or just in general officers in the Homeland Office?
No, so there's it's decision makers that sit within the competent authority that now is a single one that sits within the Home Office. We used to have two separate ones, one that dealt with cases of EEA nationals, so European nationals and British victims, and another one that dealt with third country nationals. And now they've all been put together since, I think, April this year or May, and they started working like that from now on. So you have NRM decision makers whose job is to read through all of that and then make the decision, which is great that you have specialized people that do that. However, I will say the requirements for someone to become an NRM decision maker is very, very poor. Anyone, pretty much. If you finished school, you can apply to do that. You don't have to have any experience with trafficking whatsoever. The salary is also quite low, so it's a bit over the London living wage. And yeah, so the fact that they don't have to have any previous experience in this issue when they're making such important, crucial decisions about people's lives is quite concerning. So yeah, so there were almost, did I say 7,000? Yeah, right? And then in 2008, 1,151 people received positive conclusive grounds. And then there's everyone else is currently waiting to have their applications decided. And there are some people that disengage as well, but it's not a very high number.
How many people are there that are decision makers?
I don't actually know. I don't know. Sorry. I have no idea. But I can look that and check and then send it to you. It's quite a few.
It's not like 5.
No. It's an actual team. So it's an actual division within the Home Office. And when they were starting the single competent authority, they were engaging more people as well. So they just hired more people. But yeah, exactly. I heard that. So no, it's way more than that.
On the other hand, the discretion is kind of, depends who's taking care of your file. Yeah.
So then the second step of the system is the conclusive grounds decision. So the competent authority then, once they've accepted someone as a positive, reasonable grounds, they have up to 45 days, which again doesn't only take 45 days, and they have up to 45 days to make a decision on whether on the balance of probabilities there is a reason to believe that that person is a victim of modern slavery. And in this phase, they're supposed to look back through all the documents and gather also additional evidence, talk to witnesses and to like the police or whoever they need to speak to make an informed decision. So actually in this stage, it should be when they look through everything else rather than the other one. Yeah, so as I've mentioned in the beginning, since March 2019, the support doesn't end on the end of these 45 days. It's prolonged on a needs basis. So during these 45 days, and well, actually during the time where victims are provided with support, they are supposed to have access to legal and immigration advice. And for those that don't have leave to remain in the UK, they can look into alternative ways of staying in the country. So all the immigration remedies currently in the UK are temporary. The UK doesn't provide permanent leave to remain for solely on the base of being a victim of trafficking. So you can apply for a 1-year visa, and those visas can be justified in a bunch of different ways. So it can be because you're cooperating with the police and the police needs you there, or it could be because you're receiving some sort of health assistance that you cannot receive in the country where they would send you back to, or you could apply as well to asylum and then have your asylum application go through the Home Office. If there is an issue with victims of trafficking not being able to apply for asylum if they come from countries that are not traditionally considered unsafe. So that happens a lot to Latin Americans, for example, where they might actually not be able to or feel safe to go back to their country, but because the UK doesn't consider that as a traditional country of asylum, they might refuse that person's case.
Would returning debts, like an economic reason, returning debts based on trafficking be a ground for granting visa? Like a working visa?
No, trafficking victims don't have the right to work. So it's about, well, we've dealt with your situation, now you can go home. So there's not an idea that because they've undergone extreme amount of trauma that they should be entitled to stay in the country. And a lot of them, so these are not just people that are being brought in, exploited, right? There are a lot of people that come into the UK, are then exploited in the formal job sector, and have children that go to British schools, that have spouses, they have families that are there, they have friends, and they don't want to leave. And that puts off a lot of people from even engaging with the system, because they know that they'll come to the attention of immigration authorities and they don't want to leave because they've built a life in the country. So I think that is one of the key issues with the system, is that it doesn't provide long-term solutions for victims.
Leticia, sorry, another question about the burden of proof. You said the maximum to enter the system, you have to have an imbalance of probabilities.
Mm-hmm.
So at any case, it doesn't go as high as beyond reasonable doubt, and is not connected to any criminal procedure that might. You don't have to have your trafficker prosecuted, for example.
No, you don't even have to engage with the police. So that's a decision that each individual makes. Some people do want that, also because it allows you to apply for temporary leave to remain. But if you don't want to, you don't have to, and it's two separate things. But as I've mentioned before, you don't have to have the burden of proof, but what actually happens in practice is that they're quite, I guess, petty about it, is how we've had different NGOs describe them. So, for example, we had a case where someone described a victim described in one encounter that they've been taken from one place around 6 p.m. and then there were two people in the room. One of them was dressed in a specific way, and then in a different time where they were asked to talk again about the situation, they said something like, oh, it was the end of the day and there were three people in the room, and they described the color of the shirt that the person was wearing in a different shade of the same color, and that was already considered to contradict itself, which is really concerning and goes against their own Home Office policy.
And then which would NGO, is there any other authorities be able to appeal against?
Yeah, so if you receive a positive conclusive grounds decision, you then get a document that says you're considered, and then you can go off and do different things based on what you've decided and based on the options that are available to you. If you've received a negative conclusive grounds decision, you can appeal to that. Again, it's the issue that the lawyers might not have access to all the documentation, and therefore it can create clashes again in what is being collected. But there are specific NGOs in the UK that specialise in overturning decisions, and it does happen. But it's a lot of work to then go through all the process with that person again, because it's very traumatic to talk about that. And also, even when lawyers do ask for that data, we've had the Home Office say that data belongs to us rather than it belongs to the victim. So, it's not a very victim-centered approach in that way, but it is possible to try to overturn the decision.
And would potential victims have any kind of legal support from the state, even if they've been rejected, or is the job solely of NGOs?
In the conclusive grounds decision, they would have already received support. So the support, once you receive positive reasonable grounds decision, all your support starts from then on. So you already have accommodation, therapy, all of that provided to you. Legal aid, immigration advice, all of that within that period. And then if you receive a negative conclusive grounds decision, in theory, you should have already received at least 45 days, because the Home Office is not going to take less than 45 days to make a decision.
So you would have a lawyer accompanying you throughout the process of decision whether or not you're entitled? So
you get legal advice, and you get a caseworker, and that caseworker is not necessarily a lawyer. It's kind of like a social worker that is supposed to support you through that and put you in touch with a lawyer if you need to, and all of that. What we find that in practice is that when someone is in the country and doesn't speak English, for example, and the caseworker is very unlikely to speak their language as well, they end up quite isolated. And because the accommodation is not based on the place where you live, you can be sent anywhere in the country. You can have built all your networks in Manchester, for example, but then be sent to the south of the UK because that's where they have a placement for you. So while we understand that in some cases that's necessary to kind of take that person away from a dangerous situation and then move them to a place where their traffickers can find them, at the same time, if the person is not in no immediate danger and they want to stay around their networks, I don't see a reason why they shouldn't be able to, but then there's also issues with capacity and so on. And people don't have to go through support accommodation. They can live with family or with friends if they want. So it's a choice rather than, yeah. So the caseworker is supposed to provide the support and connect the person with all the support that they need, but because of the language barrier, what happens is that the person can't really communicate what they need to the caseworker. And the caseworker often only comes once a week to give them the subsistence rate, which is their financial entitlement. And we were told that sometimes they just come, give them the money, and then leave. So
no interpretation services?
It should be provided, but it's not necessarily. And it really depends on the language the person speaks and where they are in the country as well.
And also for legal, how can the lawyer communicate?
No, for the lawyer there is, yeah. So it's just in terms of the caseworker. Yeah, and this ongoing...
Can I just also ask
yeah.
about the placement, the accommodation? Is it a shelter or it's...
Yeah, so there are shelters, there are like apartments that are used as shelters as well, so it varies depending. So there's some that are like a proper shelter with multiple people living in it, and they're both shelters for men and for women, and there are some that are specialized in supporting women and then that are run by women's rights organizations as well.
all run by NGOs?
They are, yes. Sorry?
Who manage the shelters? NGOs?
Yeah, so something called a victim care contract, that is a contract given by the government to... The way it's done now, it's given to the Salvation Army, and then the Salvation Army will subcontract other organizations throughout the country, and then they will manage the casework around their area.
So it's funded by the state?
It's funded by the state.
And
Yeah.
supervised by the state?
And yeah, it should be, yeah. And I can't remember how many years it is, but now it's up for tender again. So, yeah.
The same NRM officials that are making the decision for how long the students can stay in the country, because we set up to 45 days, and then based on a needs basis, who decides the needs basis?
Yeah, so that's the point. This was decided in March, right? So since then, we've been pointing this out. Like, who gets to make this decision? Is it an independent doctor? Is it the caseworker? Who is it? And so far, people have just been provided with the additional support, and the caseworkers that we're in touch with will say like whether or not they feel like that person can stop receiving support or what else they need. But there is currently no guideline on what needs basis means and who gets to make that decision, and we would like to see it being independent and not being a decision that is made from within the Home Office. I'm aware of time, but yeah. Okay. Yeah, so in terms of barriers to accessing the system, as you can see, there are quite a few. So there's a lack of understanding from government and first responders of what labor exploitation actually looks like. So through our work with the Labor Exploitation Advisory Group, we meet with different government representatives and first responders on an ongoing basis to explain to them what we're seeing on the ground and what different sectors experience and what that looks, how alike there is and also how different it can be. We were told by different victims at different times that if you're not a stereotypical victim, you're very unlikely to be recognized even for a reasonable grounds decision. And by that, I mean, for example, if you're a domestic worker and you've come to the UK not in an overseas domestic worker visa, but you might have come as a tourist and started working and you were working at someone's house, you had access to your passport, but there was still coercion, you were still working very long hour days. You might have been physically and verbally abused, not have had like any type of access to support or with like knowledge of what your rights are, and have been constantly told by your employer that you have no right to be in this country, and therefore if you seek any redress, you're going to be deported. We've had cases like that be refused for not having enough proof that the person was a potential victim because they had access to their passport. So there's a lot of misconception around what trafficking actually is and how labor exploitation specifically develops. So the way that we've identified that exploitation happens is that you might actually, so exploitation happens in the continuum, right? From the minor abuses that we've mentioned, like unpayment of holiday pay or lack of access to breaks during your work, all the way to really severe cases of physical harm and threats, and your passport being removed, and sexual abuse and all of that within the workplace. But because, and the UK government, by the way, has agreed to that, so they agree that exploitation happens in the continuum, and that to prevent exploitation from happening, we have to ensure that the labor law is followed, and people should have access to identification and support prior to the situation becoming so bad that they're actually trafficked or forced into different types of work. But what happens in practice is not necessarily the case. So the issue with identification and understanding what trafficking actually looks like, it's still quite poor. And I think it comes as well from the fact that you don't have specialized people doing the identification. And if you don't have that, then if someone comes to a police station, for example, which has happened, and says, I haven't been paid for 3 months, the first question that they get asked is, where's your right to work in this country? And then if the person doesn't have that right to work, they don't even sit down with them to uncover what else has happened. They call immigration enforcement on that person. Also because working without documentation in the UK is considered a criminal offence on the worker's part. So the police has the duty to notify immigration authorities.
Only on the workers'
part? On both parts, but it's a very strange system where if your employer doesn't know that you're undocumented and hires you, if they find out, but they tell immigration enforcement once they find out, they don't face any charges, and they don't have to pay any fees. If they hire you knowing that you're undocumented, but then they tell the immigration enforcement about you working for them, even though they're also in the wrong, their fee gets deducted significantly, and they don't face like jail time and all of that. So it's a system that really encourages people to report. Yeah. And it encourages exploitation, exactly. Yeah, exactly. Oh, sorry, yes. We find that with non-stereotypical labor sectors, for example, cleaning, catering, hospitality, identification is quite low. And even when NGOs do identify people and say this is clearly a case of trafficking, you might not be able to get someone referred into the NRM. As we've talked about before, insecure and undocumented immigration status really acts as a barrier for people to want to enter the NRM because they don't have any long-term immigration remedy in the end. So if they want to keep living in the country, they might not want to go through the formal processes, and that might also mean that they can't recover unpaid wages and any of that. And actually, if you're undocumented and you were working in the UK, you might not ever be able to recover unpaid wages because the act of work was criminal. Therefore, you shouldn't have been paid at all. The no control over where the victim is going to be housed if they decide to enter the NRM, lack of a tangible outcome following the conclusive grounds decision. What also happens is that European nationals, because they can work and because they can move around freely, they decide they don't want to enter the NRM because they don't see any necessarily anything tangible to gain from that if they already have a house, for example, and if they don't want to access counseling services. There is also many cases of delayed identification of victims due to criminal activity. So if someone has been involved in, for example, cannabis cultivation, it's quite common that the police will come in and do a raid in a house where they were cultivating cannabis and then arrest everyone. People will be charged for that crime, go to prison, serve their sentence, and then once they're being considered for deportation, they will then be identified. I mean, some are not and then are deported before they're identified, but we're finding a lot of cases of people being identified after they've served a sentence that was linked to their trafficking. And there's also an issue with poor identification within immigration detention centers, and that's both with people that have been in the criminal system before and people that have just been picked up because of their undocumented status. And that's because the only first responder in immigration detention centers is essentially the Home Office. So when you have identification and enforcement of immigration policy under the same body, it's quite a conflict of interest.
What about in cases where the victim is cooperating with authority and giving like testimony, is a witness, like a key witness in a criminal case? Right. Mm-hmm. Are they receiving any kind of visa? I mean, usually
so
the procedure also takes a long time.
The police can apply for temporary leave to remain, so we call it discretionary leave to remain, and that
with a work visa?
No, and that's. I don't think so, no. And they...
sometimes it takes years.
It does take, yeah.
They don't work all the time?
They're
not entitled?
I don't think so, no. I think if you finished your trafficking case, it might be considered that you could be allowed, but it's not a given that you are allowed.
You're taking testimony, even though it could take years, you're not allowed.
Yeah.
They just get the small financial support.
Yeah, and in the case where there are cases, for example, where the discretionary leave to remain has been denied because it was said to the victim that, well, you can go home and we can either bring you in to testify or we can Skype you in. So it's not granted that you'll get that, even if you're cooperating with the police. But it does happen, and the police can apply for it on behalf of the person as well.
Does the law or the NRM include also British citizens or only foreign?
Yeah, it does include British citizens.
You could be a victim of modern slavery even if you have status.
Yeah, of course. Mm-hmm.
You weren't transferred if you were within the country.
Yeah, because then it would fall, for example, under forced labor, for example, and not fall within the trafficking, the UK definition of trafficking, which is the movement.
And in those cases, do they also receive some kind of aid or
They do. They are entitled. Everyone is entitled to the same things. The only difference is that if you don't have status, then you also have on top of that all the immigration issues. Yeah, but everyone is entitled to the same stuff. So very quickly on what a victim-centered identification and support mechanism looks like. So ideally, prior to entering the NRM, you would already have access to safe accommodation, legal and immigration advice, and counseling to ensure that you have time to make an informed decision. This is going to start being trialed, so the pre-NRM support that the government has agreed to give is a 3-day support where people are given safe accommodation and then they can reflect on what they would like to do. There's an issue with this at the moment that it seems like the only people that are able to refer victims into this safe accommodation that we call places of safety are either law enforcement or immigration enforcement, which, I mean, will then discourage people from using that as well. And the idea with the system is that it will ensure confidentiality and informed consent because people will have more time to think about their situation. Victims should have access to their referral forms and they should be able to ask for a copy if they need it and if they want it. Support should be given on a needs basis, as we discussed, and the need should be defined by an independent decision maker rather than by the Home Office or any kind of immigration-related body. Victims should have the right to work while they're in the NRM, because we've seen that the right to work really improves their ability to recover. And they don't, but they should.
These are your recommendations.
Yeah, this is what we would like to see the system look like. The NRM decision-making should consider the impact of trauma on someone's account of their experience. And as I said before, NRM decision-making has been described as very petty and pedantic by by those supporting victims.
I would like to understand one thing. They are not allowed to work, but what is the sanction? They can't be deported. What?
They don't get paid.
What do they expect?
Translating are sanctions.
Let's say that they do
They do work. So
They are then in breach
of.
of.
Right work means in the situation that you are not being deported, you get.
So they're, in theory, in breach of the illegal working offence, right? Yeah, and they could be detained. You're not.
They commit a crime.
Yeah, it's a criminal activity.
Victim of forced labor, and you work after that, so it's possible to detain you.
Yeah, and you can be in detention while your case is being decided on. So. The UK doesn't consider keeping someone in detention as going against the EU convention.
And what happens if a victim is identified in detention?
They can be released, but they can also stay. It will depend.
It's possible to be recognized as a victim and all that, and still be detained?
Yeah, and still be deported afterwards as well.
Judicial review of this kind of acts? Either UK tribunals or EU or European Court of Human Rights?
Yeah, we've had an issue last year, which was there were two cases where two victims of trafficking had been identified and within detention and not allowed to leave, because the way immigration detention works in the UK is that if the risk to immigration control factors, which is what they call, which is like security and risk of reoffending or absconding, for example, are higher than your level of vulnerability, the Home Office can keep you in detention. So then these two people took the Home Office to court to say that wasn't compliant with international standards. And the High Court in the UK decided that it is compliant, because people in immigration detention centres have access to safe accommodation, they have access to medical support, and they're safe. And then it even said that in some cases you're actually better off in detention than you are outside. So it's not ideal. Sorry. Yeah.
I'm getting a lot of questions.
Yeah. So and then the last thing is the long-term remedies, which include both the right to work and to eventually settle in the UK if you want to settle.
The non-punishment principle of trafficking.
Exactly.
Basic principles.
Yeah, the court didn't agree. So the last thing is that if you're considering having an NRM system, these are the things that we consider are really useful to gather in terms of data to understand whether the system is working, but also to get a better picture of what exploitation looks like in the country. So as I said, in the UK, we don't separate things by which first responder has, we have a number of how many referrals a first responder has made, but it doesn't go all the way to the decision making. So we don't know whether some first responders are making really good referrals while others are not doing such good ones. So it would be really useful to have the outcome of cases based on which first responder has made the referral, what is the nationality and visa type of the victim, to see whether there's a bias around people that have the right to stay and people that do not, where the referral was made, so whether it was made within an immigration detention center or if it was made within the community, the length of time between referral and conclusive grounds decision, that is not currently measured, or at least not published, and also recording the different types of exploitation and the different labor sectors that exploitation has been identified with, because depending on the kind of exploitation and the sector of exploitation, that will require different solutions to prevent it. And then the police and different law enforcement bodies can use this information to then target operations and proactive labor inspections and all of that. And then that would also help then establish systems where businesses operating in these sectors can prevent exploitation from happening. And I've just left some resources that I think could be useful. The first one is the one that I've brought some hard copies of, and then all of these, I can share that with you and then you can circulate with everyone else. And the Human Trafficking Foundation Survival Care Centers is really useful. It was written by various NGOs, and it talks about all the best practices in supporting victims while they're going through the system. So from the pre-NRM to post-NRM, what an ideal system, or the system we would like it to be like, should look like. Yeah, that's it. Thank you.
Very much.
So, thank you very much, Leticia, for this really, really interesting and important talk. And what I would like to try to do,
Can you hear in the back?
You hear me? Okay.
Slower.
אני עושה מה שמיכל אומרת. I would like to try to do three things to link the discussion of the context of the UK to the discussion of Israel that we're going to have in greater detail in the next session. And I assume that what we're having now is the beginning of a much longer discussion that will have to happen in different contexts. And I would like to highlight three main themes. One of them is what I'll refer to as a trafficking orientation or framework compared to a modern slavery orientation. The second is the tension or the decisions between formality and flexibility in the system. And the last, I'll have a short point on data and what to do with it. So first, trafficking and modern slavery orientation. Israel in general, in this as well as other things, follows pretty much the approach of the US in the TIP report and the TIP approach. And the US trafficking approach, perhaps less in the last couple of years, but still is very much still oriented towards trafficking for sexual exploitation. It's still, the approach is very criminal and border control. And we know from researchers and data about identification in the US that in the US, identification is still mostly trafficking for sexual exploitation, and there are very poor mechanisms for identification of labor exploitation. And part of thinking in the idea of identifying labor exploitation, identifying modern slavery, is some sort of paradigm shift, moving from how people got here, how people got where they are, to what condition they face in the situation they're currently in. And in the UK, we discussed the NRM, but the NRM is part of a broader system of addressing modern slavery beyond criminal enforcement that includes, for example, supply chains. I'm not going to get into an entire paradigm shift of everything to do with modern slavery. We are talking about identification, but I think it's important to note that identification of victims happen within a broader context and within a broader system, and part of the thinking of identification must take into account this broader context and how identification fits within this broader system. And one point related to that, Leticia mentioned definitions, and I think Israel has a good working definitions of slavery, including servitude and forced labor. We need to do more with forced labor, but the legal definitions are not bad. And the legal definitions cover the spectrum of what is known as modern slavery in the UK, both in covering the means in Israel, because in addition to the powers exercised against property, which is a more problematic part of definitions, we have the definitions of substantive control over the life of person and denial of liberty, and we have work and services, and it's a good
Definition within the law?
the legal definition within the law. And the interpretation of those definitions by the courts in Giuliani and in Ambush are good interpretation. They're broader than the instruments in international law. They're broader than the instruments in European law. So, and this is even when we're talking about the highest level of interpretation for criminal convictions that would end in very long jail time. So if we're thinking about those definitions for administrative procedures, for protection, for working with victims, we have useful definitions to work with. And one main issue that links to what Leticia mentions about having good policy and problems with implementation is working with those definitions and making sure that the standards used for administrative procedures, for protecting victims, are not de facto higher than the standards that the court said is enough to send somebody to jail. So there needs to be some level of consideration here of we're using criminal standards, but we are using them in something that's human rights, humanitarian protection, and they should be read in this context. This is one aspect of implementation. Another aspect of working within a system, and again, this links to the understanding how labor exploitation works in specific sectors and understand sector-specific and immigration regulation-specific context of exploitation, is understanding the relevance of systematic problems and categories of vulnerability to identification, and how being in care sector or agriculture or coming from there or subject to this regulation is relevant for your identification. And I think an interesting point here that Leticia mentioned, identification of victims in stereotypical versus non-stereotypical sectors, and difficulties in the UK in identifying in non-stereotypical. And I would suggest that in Israel, perhaps we're faced with the opposite difficulty, because the cases we see that are identified and get all the way to criminal indictment and to criminal convictions are mostly the non-stereotypical cases. There are cases of extreme cults, there are cases of family abuse, there are definitely cases of sexual abuse and trafficking for prostitution, but we don't see, we definitely don't see convictions, and we hardly see indictments, and we hardly see identification in the broader regular cases, sectors of construction, agriculture, care, some things in hospitality. And this is part thinking about identification, part of thinking of the stereotypical, non-stereotypical, and I assume it will be addressed later, is how we identify people within the stereotypical cases, how we think about victims in sectors that are, the entire sector is vulnerable. And I think this links to my second point about formality and flexibility. And the NRM in the UK, like other things, and I don't think I'm saying anything new about formality and flexibility in the British and the Israeli society here, that the NRM is a formal system. We heard about many things that are not applied consistently and guidelines that are not implemented, but the system itself is formal, and there are formalities, there are forms to complete, and exactly what data is required and how it is used, and who is responsible for collecting data at any point, and who should report to each body, and who makes decisions in each state. And while I agree, and I think we all could agree, that the system in Israel requires improvements, and some parts of it perhaps requires restructuring and rethinking, one question is, when trying to improve it, what will require more formality? And are there good things in a less formal system that we can maintain, that we can preserve? And I won't try to offer an answer for this, but I would try to offer some questions that I think are useful to think of formality and flexibility. So one point is response times. that some cases, and we know in Israel that some cases could be decided even on the very same day or the next day. Somebody from the NGOs will be in touch with the police will understand the urgency and severity of the case, and a person would be referred to the shelter, and this is the last time this person has to worry about most aspects of rehabilitation and protection, which is amazing, and this is something that clearly needs to be an option. But the other side is that sometimes cases could wait months, could perhaps wait a year, sometimes more. I know that waiting times are improving, and it's a great thing, and there are more resources on that. But thinking of a way to make sure that urgent decisions could be made the same day, at least as far as the victim is concerned, but also that the same informality doesn't mean that other cases could last for months with no clear date of ending this procedure and making sure victims are protected. Second issue is the size of the sector, and we talked, and naturally there were many questions about numbers and how many people do things and how many people identify. So Israel recognizes that agriculture and care sectors are vulnerable to trafficking and slavery. We're talking about something like 56,000 migrant workers in care, about half of them in the most extreme vulnerable situations of tied visas, isolated, very limited communication with the outside. In agriculture, we have more than 20,000 migrant workers and more Palestinian workers. Some of them suffer from similar vulnerabilities. I would add to this the construction sector that is vulnerable in many aspects for the same reasons, though it's not officially recognized as such in, for example, the National Action Plan. And one of the challenges in those sectors are they're distributed around the country, and some of the most vulnerable workers are isolated. And this, of course, is part of what makes them vulnerable. But it also raises the question, when we're thinking of identification, how many people need in Israel to understand slavery, where they need to be geographically, where they need to be in which institutions, for those workers to have some reliable contact, somebody who sees them, somebody who meets them, or they meet, or they could approach and could recognize them. And one question is, given those numbers and given their geographical location, who can be a first responder, and what do they need to know in order to be an effective first responders? And one challenge, if we agree that identifying 5 or 6 or 3 or 10 victims a year is not the numbers that the referral mechanism in Israel should see, and we are talking larger numbers, we can't trust a system that works based on somebody in the NGOs knows somebody in the Ministry of Justice or the police, and they make the call, and there's a level of personal trust, and people could say, this is important, this is an urgent, and be believed. There are good things about some trusted representatives in NGOs and some people that could say, this is urgent, this is terrible, do something now, and it would work. But the system can't identify effectively all the victims that we're now missing and still work like that. And I'm talking about NGOs, but we see from data that we received from the government for freedom of information requests, that there are no referrals from PIBA to the police in concerns of trafficking and slavery. There are no references from the general police units to SAR unit, to the specialized officers. There are no slavery references coming from CIMI's hotline. So one challenge is not only learn how to talk to the hotline, learn how to talk to Kav La'Oved. One challenge is for other sectors to talk to themselves and identify the victims who are later identified as victims of trafficking and slavery, move to the shelter, and have some level of criminal procedures against the offenders.
But it exists.
Very, very low number. I'm using the data from Freedom of Information. I'll be happy to have new data.
No, I agree that not enough. I think there could be done more and should be done more. But it's been
Okay, let's talk later about data.
It's no longer true to say that there are no referrals from both the three bodies that you mentioned.
Okay, I apologize if I'm saying something inaccurate. Let's talk data later. And the perhaps last point I want to make about this is the use of indicators list. And there are, in Israel and the international level, there are international instruments like the Delphi indicators that make the procedure of identification very systematic. This is what you should look for. This is what each criteria accounts for, and this is what you do. And in Israel, we have the identification guidelines of the Ministry of Justice, which are very good and useful. And we have the interpretation of the courts that is helpful and tell you what to look for. And this is something that could be used. But this goes again to the question of formality of who do we trust to make the judgment of identifying those indicators, assessing those indicators, reporting those indicators, especially if we're concerned, for example, one of the points about the NRM, that training doesn't work or doesn't work well enough. Training does not make the people who are in the position to be first responders. Due to lack of understanding, due to lack of familiarity, due perhaps also, if we're talking about stereotypical sectors, to the assumption that some forms of violation are typical for care or typical for agriculture, and it's no reason for concern. So one thing that perhaps could be an interesting direction to think of, assuming that there are too many potential first responders, that they are not very specialized and they do have many other obligations. If we think of labor inspectors, if we think of PIBA inspectors, if we think of immigration detention tribunal, people that need to know a lot of information and they can't all be trafficking experts and they won't have the understanding that's here, is a very clear guideline of what to look for in a very, perhaps one consideration here could be a more formal requirements, such as questionnaires that must be filled on every interaction with migrant workers or migrant workers in vulnerable sectors, of some indicators that they must report if they encounter, even if they are not expected to explain those indicators. And one thing that could be a direction for comparison in things, a procedure that exists in Israel, for example, in hearing that were supposed to be before Cholot detention by PIBA inspectors, ממוני ביקורת גבולות, that have strict questionnaires of those are things you must ask, those are answers you must report, and then perhaps this decision could be made elsewhere because you can't be expected to evaluate all those characteristics. And this also links to the point we heard again about the NRM of using all this information, but using it in good faith and having the people making the decision, trying to use the information, giving victims the benefit of the doubt, acknowledging trauma, acknowledging the situation, but trying to gather the information they need, not count on the most basic encounter as this is enough to make this decision. And the last point I will make that is about data, because I think part of the reason we could sit here and discuss the NRM and discuss what it does and what sectors it identifies and where the problems are is because the level of data that is collected, and we heard that it's not enough, and there's major information that needed about sectors and about who is referring cases, but having data about labor exploitation and sex and age and something about nationality and region and broader data allows to have this discussion. And I do believe that having this level of data collected, published, publicly available annually in Israel, that alone would be a major step forward, even if it's not accompanied by any clear we need other things. But this would be an important step, because one thing, and I mentioned earlier, the broader context of the Modern Slavery Act and transparency in supply chains. And one of the things that slavery experts in the UK, including those coming from more institutional places, agree that considering transparency in supply chains, the most important things for corporations is to actually report the problems they see, even if sometimes it would make them look bad. It's more important that they will report the problems, that the system will try to overcome its instinct to criticize them for that, but try to find solutions. And the same is true, at least in a certain level for organizations and for a governmental level, that there's need to be an informed discussion. And there needs to be an informed discussion where people like Ministry of Justice and PIBA and Labor and Foreign Affairs and NGOs and academia, if we could help, everyone has the data and trying to make it as helpful as possible. And this transparency, it would work for what we can discuss and what we know, but it could also be useful information. Part of it because we could see where the problems are. Part of it because it could help identify best practices, because we could see some first responders do relatively good work in identifying cases. Maybe we could learn something from what they're doing. Maybe if we see that there are more referrals in agriculture in the south than in the north, then maybe there's more slavery in the south, but maybe also labor inspector in the south work according to different procedure or different emphases, and they do something better.
No, there is more slavery in the south.
That's for the experts. And another, it could also help stakeholders from the state, because we know that one of the major challenges for people in the Ministry of Justice and in the rehabilitation in the sector and in the police, definitely in the police, is resources and manpower, and have enough people, trained experts who could do this work, and being able to tell people higher up the chain, we have this data show this is where our problems are. This shows our waiting times or pending decisions. We need more people because we need to address this. There are downsides, but it could also be helpful. And I think it's important to keep in mind that significant steps in fighting trafficking and slavery in Israel happened when the problems were visible and when they were clear and when everybody could more or less agree on what we see, where we see it. And it's uncomfortable in real time, but it is helpful in the long run. And I end by saying that I think we're looking at the long run, and this is the beginning, and those are some things to think about, and hopefully we'll have more of this in the future. So thank you.